Okay, hi guys. Today we're going to be looking at breach and the standard of care in relation to them. So usually when we talk about the standard of care, the standard is judged to that of a reasonable person. So it's quite an objective test. There are some exceptions, so where the defendant is a professional or an expert in that area, they'll be held to a different standard. Also, the only time you'd look at the characteristics of the defendant is when it comes to age. So that again explains why it's an objective test. They don't look at mental illness or how educated you are, all these things. They look at the objective thing. They only provide that different special approach for things like children. Also, alongside being objective, the standard isn't always the average behaviour. It's not always what the average person would do, most people. So a good case to look at when discussing this is Nettleship and Weston. So she was learning to drive, it was her husband's car, the car was insured, and she was using a driving instructor. They were driving down, she was meant to turn, I think she panicked, she clasped onto the wheels, didn't brake, and they ended up crashing. And the driving instructor's knee was injured in the process, I believe. And the court said it was irrelevant if she was a learner. She was to be held at the standard of any reasonably confident driver. And you can use that ideology in most cases, the reasonably confident blank for whatever aspect you're looking at. However, I do think it's important to raise that this is quite an old case. It's from 1971. So I'm not sure if back then the driving instructors had their own brakes. Now that's the case, you have your own set of brakes. Some of them even have their own steering wheel. They're insured to be taking out learners. You could argue, so if you get a problem question where it seems like very different, I think raise that issue, discuss that things have changed now. The facts are quite different. And so maybe there's room for a new approach, but still discuss that old one. And so don't be afraid of looking at old cases and trying to put them into a modern approach, as long as you do establish that that is the case, that's the current law, that's most likely what's to be held. Don't make up a case on your own when you have all of this precedent to rely on. So when discussing breach and standard of care, we have to consider quite a lot of factors. These include foreseeability, the magnitude of the risk, the practicality of the precautions taken, the utility of the defendant's conduct, and also whether or not this is common practice. So firstly, I'd like to discuss foreseeability. So you can only take precautions against foreseeable risks. If you can't foresee the risk, it's very unlikely you'd be able to act in a way to prevent it. And you can only foresee what's available with the information at the time. So if we look at Roman Minister of Health, they had an operation, the anaesthetic was contaminated and it resulted in the claimant becoming paralysed. The contamination occurred through, I think, tiny scratches on the glass which it's stored in. However, that information was not available at the time the operation took place. The operation took place in 1947 and this information wasn't made available, it wasn't even known until much later. There's a quote in that case which says you can't look at 1947 with 1954 glasses. If it's unforeseeable at the time, you can't impose liability on the defendant because it would be unfair to. How are you meant to take precautions against the risk which you're completely unaware of? Okay, we can then move on to the magnitude of the risk. So how likely is that harm would occur? Because say it's a 1 out of 1 million chance, I'm making up numbers, but it's such a negligible risk, you're not expected to take precautions against that. It would be extremely difficult to make sure you've covered every single risk, no matter how small. For this, you can look at the cricket cases, they're called. So it's Bolton and Stone, Miller and Jackson. So in Bolton and Stone, I think their fence was, 18 feet high, and the ball had only gone beyond that, 3 times in God knows how many years. So it was such a small thing, and they'd taken reasonable precautions for it. you wouldn't have been able to find liability there. However, in Miller and Jackson, the balls kept going into the houses around the area, breaking glasses, these kind of things. And they had quite a high fence. However, they said they could have made it higher. That fence was reasonable for the time before all of those houses were built. That was no longer reasonable to have it that short, and it was happening so often that they should take precautions against it. You can also look at severity of potential damage when talking about magnitude. So how severe is the outcome? So for the Paris case from 1951, he only had sight in one of his eyes, and they said you should obviously provide goggles for him, because if he loses sight in his other eye, he's gone completely blind, whereas one person would still have vision left in one eye. There's a bigger risk for him. It's more severe. So for something that's more serious, you should take greater steps to prevent damage. And you can also look at Harris. So they were on a bouncy castle. It was a birthday party or something like that. There were kids on it. One of the older kids had actually accidentally smacked into or hit one of the younger ones, and the younger child suffered serious injury. However, you'd look at that and say there was no way that they could foresee such severe damage happening from children on a bouncy castle. They did everything that was reasonably expected of the reasonable parent. What more steps could they have taken? So we can also look at the practicality of precautions. So how much would it cost to do it? How easy is it? What's the effect? Does it make it impossible or really difficult to achieve? Is it practical, basically? And you'd look at Latimer. So in Latimer, there was an oil spill, there was oily residue covering the floor, and they partially covered it with sawdust. So the reason they partially covered it was because that was all the sawdust they had, so they covered as much as they could. Someone slipped and injured themselves, and the court held that their actions were in proportion. They couldn't have been expected to close down the whole area. That would have been an unproportionate action. You can't expect the reasonable person to take these unproportionate actions. It's not a reasonable behaviour to adopt. And it's also worth noting at this time the economy was very important. It would be highly unlikely that they would have been able to afford closing down the area. We can then discuss the utility of the defendant's conduct. So basically, how useful was what they were doing when this breach occurred? So in Wotton, Hertfordshire County Council, there was a woman, she was trapped under a lorry, and they had to use a jack to take her out. So the equipment wasn't properly secured and the jack fell on the claimant. And then they said that because there was such a great use, it was a very time sensitive situation, they didn't properly secure it in order to save a woman's life. That greater use means they were less likely to be found negligent, which they weren't. We can also look at the Compensation Act of 2006, Section 1. So it basically reads that people engaging in socially useful activities shouldn't be discouraged by fear of negligence. So if you're doing something for the benefit of the public, you're trying to run a class to make everyone a bit healthier, these kind of things, you shouldn't be discouraged. You should be able to do that without having this fear of, I'm going to be sued. And it seems like it gives a lot of leeway, however there is a limit. So if you look at the Scout Association in Barnes, I think they were playing Blind Man's Bluff, something like that. However, they turned the lights off. And then obviously accident occurred, and they said that turning the lights off didn't increase the gain in any way, it just increased the risk. So it wasn't enough to say it was socially useful. The socially usefulness was at the same level with the lights on or off. They just increased the risk of injury to the children, and so they were found liable. It wasn't useful conduct. We can also refer to the Social Action, Responsibility and Heroism Act of 2015, Section 2. So court must have regard to whether the alleged negligence or breach of statutory duty occurred when the person was acting for the benefit of society or any of its members. So it talks about responsibility and heroism. So if someone's drowning and you try to save them, you breach that some duty owed. In that process, it's understandable. You were trying to do something that was so useful and important, and I think moral as well. That's quite important because we're a society that works based on morals quite highly. Courts should take that into consideration when making their decisions. I'd also like to discuss common practice now. So common practice, it's seen to be the reasonable standard. So if everyone's doing this, you have to justify why you haven't followed this, why you've gone in another direction. However, this doesn't say that you always have to follow the common practice. So in Bolitho, it said that where other practitioners would do the same, they'd follow this, and the method's logical and defensible, it's not a breach. You still follow the reasonable standard, even though it isn't the common practice. So there was a case, I think it's Sutcliffe. It was a private healthcare, and the patient had surgery, and they, I think, aspirated, so their airway was blocked due to the nausea. They suffered brain damage, and the question was, why wasn't he checked on, woken up, stopped? Why wasn't this prevented? And it was held that it was the normal standard to allow patients to sleep off anaesthetic after surgery. They wouldn't have realised this, and also because it was private healthcare, the rounds are a lot longer. So whereas if you're in public, I think you share a room a lot of the time. There's always someone there. Whereas in private healthcare, there's less staff. You're in your own room. It was normal for that to have occurred. They didn't act in a negligent manner. They didn't breach their duty. So, leading on from healthcare, we can talk about the professional standard of care. So this says where the defendants are professional, where they're held at a higher standard because of their skill, their expertise. An important thing to realise is the idea of informed consent. A lot of the time, the doctors would be able to only tell you what they wanted to back in the day, whereas now this is no longer the case. If you look at Montgomery and Lanarkshire Health Board, it basically says, it talks about the idea of informed consent. Patients should be able to make these decisions completely informed as to what risks they're exposed to. They're able to decide what's best for themselves. We're in such a society now where we should be able to decide what happens with our bodies. I mean, also the reason that's occurred is because of the internet. There's a lot of information which we now have accessible, which weren't back in the days. We're able to find out a lot of the things, and we shouldn't be stopped from doing so. We can also discuss Cheshire and Ayrshire. So in this case, the patient asked what was the risk of something happening to her. I think it was like paralysis, something like that. She was having back surgery. And the doctor turned around to her and said, well, I haven't crippled anyone yet. He didn't answer the question. And then she went in. Nothing was wrong with the operation, but that risk did occur. There was no negligence. It was just she was the one out of how many. And she even said that she would have still done the operation anyway, but the courts allowed her claim because they said she wasn't able to consider that risk. That opportunity was not given to her. We can also look at BOLAM. BOLAM is quite important. So BOLAM basically says where you've used your professional opinion. So again, the idea of common practice, where you've used your professional opinion, you've gone your own way. This has to be supported by one responsible professional body of opinion. So that's the principle. You're held to the standard of a reasonable person with the skill that you're claiming to possess. That has to be regarded as proper by one body of professional opinion, even if other bodies don't think it's proper, if other bodies think it's negligent. If you can find someone to support it, it shows that someone else believes that it's not completely negligent. It is an idea which is in that sphere. And then lastly, and this was introduced by Belitho, if the person giving it was not responsible, and if the evidence itself is not responsible in the sense that it does not withstand a logical analysis. That basically says, even if someone else turns around and says, I would have done the same thing, if you look at that and analyze that situation and it doesn't seem logical for that outcome to have arisen, you will still be found liable. It has to withstand a logical analysis. So we can also discuss children and their special situations. This is the only time where you're going to look at another factor, a subjective aspect of the person in question. So with so in Mullins there was two, I think, 15-year-old girls. They were play fighting with rulers. One of the rulers snaps, went into the other girl's eye, and it caused blindness. There's a lot of discussion about this case saying, okay, at the age of 15 you'd be able to realize this, but you can look at it as, okay, maybe a 15-year-old girl would have realized I can accidentally hurt my friend in this manner, but they wouldn't foresee that you'd blind your friend in a mere rule of fight. They're children, they're held to a lower standard. They may not realize all the things that adults would. The same kind of thing applies in Orchard and Lee. There were 13-year-old boys playing tag, so you'd say that it's such a normal game to play at that age, you wouldn't foresee injury occurring because it's at that age, it's completely normal to play the game. Barely anything will happen. There's very small risk to apply with it. So again, they're held to a lower standard at a lower age, and that's really important to consider in a lot of cases. So it's also considered in a lot of defences, such as contributory negligence, which we'll discuss in a later lecture. But if you get a problem question where there's a child involved, don't stick to the objective test. Take into consideration that they may lower the threshold of all these requirements because it's a child in position.